Right now, today, in 2026, there are millions of law-abiding Americans who bought a firearm legally, registered it, kept it in their home, never pointed it at anyone, never committed a crime, and are now, through no fault of their own, standing in the crosshairs of federal enforcement, state prosecution, or both, not because they did anything wrong, not because they're dangerous, not because they're criminals, but because the legal ground beneath them shifted while they were living their lives and nobody sent them a memo. That is what this is about. That is what you need to understand before we're done here. We are talking about the most significant legal changes to firearms ownership in decades, and they are not coming. They are already here. In 2026, gun owners who never broke a single law are facing real criminal exposure. And the system that is supposed to protect their rights is moving slower than the enforcement arm that is coming for them. If you own a firearm, any firearm, what I'm about to walk you through is not theoretical. It is urgent. It is happening right now, and you owe it to yourself to understand it completely. If this kind of journalism matters to you, the kind that doesn't soften reality or pick a political side, just tells you what's actually happening, hit that subscribe button right now. We cover the stories that affect your life, your rights, and your freedom, and we don't sugarcoat a single word of it. Here is what most people do not understand about the 2026 firearms legal landscape. It is not one law. It is not one court case. It is not one federal agency acting alone. What is happening right now is a convergence, a collision of four separate legal forces, all moving at the same time, all aimed at different categories of firearms, all with different enforcement timelines, and all with the potential to turn an ordinary, responsible gun owner into a criminal defendant overnight. The first force is federal administrative rulemaking. The ATF, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, using the broad and often vague language baked into existing federal firearms statutes to expand its regulatory reach into categories of guns it was never explicitly given authority to regulate. Ghost guns, pistol braces, short-barreled configurations, solvent trap kits. These are not areas where Congress passed new laws and said regulate this. These are areas where a federal agency decided its existing mandate was wide enough to cover them and started writing rules accordingly. Some of those rules are finalized. Some are in litigation. Some have been struck down. Some are on appeal. And all of them are creating a legal fog so thick that even experienced firearms attorneys are navigating it carefully. The second force is state-level legislation, and in 2025 and now into 2026, this force has accelerated dramatically. States across the country have passed or are actively considering assault weapon bans, high-capacity magazine restrictions, but semi-automatic action restrictions, and outright prohibitions on home-built or unserialized firearms. The patchwork of state law has always been complex for gun owners, but what we're seeing now is not a patchwork. It is a quilt of contradictions, where something completely legal in one state is a criminal offense, and the moment you cross a line on a map. And for gun owners who live near state borders, who travel, who visit family across state lines with a firearm in their vehicle, that contradiction is not abstract. It is a potential felony charge waiting to happen. The third force is the ongoing Supreme Court litigation that came in the wake of the landmark 2022 Bruen decision, which fundamentally changed how courts are supposed to evaluate at Second Amendment challenges. Bruen was a genuine legal earthquake. It required that gun regulations be rooted in the historical tradition of American firearms regulation at the time of the founding, not just pass a modern balancing test. That single standard change unleashed a flood of legal challenges to laws that had been on the books for decades, and the federal court system is still processing that flood. Different circuit courts are reaching different conclusions. What is constitutional in one circuit is unconstitutional in another, and until the Supreme Court speaks directly on the specific questions still in play, gun owners are left living in legal limbo, where the answer to, is this legal, genuinely, depends on which courthouse you'd end up in. The fourth force is local enforcement prioritization, and this is the one that surprises people the most. Even in states with relatively gun-friendly laws, local district attorneys and law enforcement agencies are making independent decisions to pursue technical violations that were previously overlooked, things that prosecutors used to look past, minor compliance failures, technical configuration issues. Paperwork irregularities on transfers are now being treated as prosecutable offences in jurisdictions where the political winds have shifted. Understanding all four of these forces is not optional background knowledge. It is the foundation of everything I'm about to tell you. Let's start with the category of firearms affecting the largest number of gun owners right now, and one that has been sitting at the center of a legal firestorm for the past 3 years. Pistol brace-equipped firearms. Here's what you need to know and why it matters so urgently. In 2026, pistol stabilizing braces, devices originally designed to assist disabled shooters in operating large-format pistols with one hand, were sold legally by licensed dealers for over a decade. Millions of Americans purchased them. The ATF itself, on multiple occasions, issued letters acknowledging their legality. Gun stores sold them, major manufacturers built them into their product lines, nobody was hiding anything, nobody was doing anything wrong. These were sold legally, purchased legally, owned legally, and used legally by millions of Americans for years. Then in January of 2023, the ATF issued Final Rule 202, 1R08F, reclassifying many brace-equipped pistols as short-barreled rifles, a distinct category, regulated under the National Firearms Act of 1934. The NFA is serious federal law. Short-barreled rifles require registration with the federal government, a tax payment, extensive background checks, and compliance with NFA transfer rules. The ATF's rule effectively told millions of Americans that the legal firearm they had legally purchased had, through regulatory fiat, become a heavily regulated NFA item, and that they needed to either register it, modify it, destroy it, or surrender it. Think about what that means for a moment. Think about the audacity of what that means. A federal agency, without an act of Congress, redefined millions of legally owned firearms and handed their owners a compliance deadline. Not a law passed by elected representatives, a regulatory rule written by bureaucrats. The legal challenges came fast, and they came from everywhere. The Fifth Circuit Court of Appeals, which covers Texas, Louisiana, and Mississippi, issued rulings that significantly constrained the ATF's authority in this area. Finding that the agency had exceeded the bounds of its statutory mandate, other courts reached different conclusions. And now in 2026, the legal status of pistol brace regulations is, and I want to be precise here, genuinely unsettled. The Supreme Court has accepted related cases that examine the scope of ATF regulatory authority, and the outcomes of those cases will directly determine whether millions of Americans who bought legal firearms are in compliance with federal law or are sitting on unregistered NFA items. The case law is not resolved. The regulatory status is not clear, and the enforcement environment is active. If you own a pistol brace-equipped firearm, particularly one with a barrel shorter than 16 inches, you cannot afford to assume you know the answer to the legal question. The answer depends on your specific firearm, your specific state, and the most recent court holdings in your circuit. That is not a generalization. That is the actual legal reality of where we are in 2026. Now let's talk about the category receiving the most aggressive federal enforcement attention of any firearms category this year: unserialized, privately made firearms, what some people call ghost guns. And I want to be direct with you about something before we go further. The framing of ghost guns in mainstream media coverage has been almost entirely about criminals and crime, about untraceable weapons showing up at crime scenes. That framing is not wrong, but it is deliberately incomplete, because the vast majority of people affected by the ATF's regulatory action in this space are not criminals. They are hobbyists. They are people who built a firearm at home, the same way people have been building their own firearms in this country for literally 2 centuries, going back to long before there was a federal government with an ATF home manufacture of firearms. For personal use has a history in America that predates the Constitution itself, and it has never been federally prohibited until arguably now. The ATF's Final Rule 2021-05F redefined what constitutes a firearm under federal law. Specifically, it brought certain parts kits, polymer frames, unfinished receivers, 80% lowers under the definition of a regulated firearm, requiring that they be treated the same as fully manufactured firearms for purposes of background checks, serialization, and licensed dealer involvement in transfers. The rule was challenged everywhere. It went to the Supreme Court, and in 2024, the Supreme Court issued its decision in Garland v. VanDerStok, which upheld significant portions of the rule while leaving open additional legal questions that courts continue to address as of right now. The practical implication of that decision is serious. If you built a firearm at home from a parts kit, even years ago, even when every component was sold freely without restriction, even when no law required any registration or serialization, the current regulatory environment creates genuine legal uncertainty about your compliance obligations. Here's the part that should make your jaw tighten. The federal government is not abstractly interested in this issue. Federal enforcement of ghost gun regulations is being specifically prioritized. Resources are being directed toward it, cases are being brought, and at the state level, California, New York, New Jersey, and several other states have enacted laws that are significantly stricter than federal requirements, laws that do not have the same legal ambiguity around whether you have to serialize, register, or surrender an unserialized firearm you built at home. In those states, the answer is already clear. It is legally enforceable, and prosecutors are using it. If you own any unserialized firearm, the conversation you need to have is not with me, and it is not on the internet. It is with a licensed firearms attorney in your state who can give you a specific legal opinion about your specific situation today, not next week. Let's move to assault weapons, a phrase that means different things to different people, but in the legal context means something very specific, depending on which state you live in. And in 2026, the legal consequences of getting that definition wrong could not be more serious. Because we are not talking about future legislation being proposed or debated. We are talking about laws on the books right now, with real criminal penalties, active enforcement, and compliance deadlines that have already passed in some jurisdictions. Illinois is the most important example to understand, and the situation there should serve as a warning for gun owners in every state where similar legislation is moving. The Protect Illinois Communities Act banned assault weapons and high-capacity magazines and required existing owners to register their firearms with the Illinois State Police by a specific deadline. The law was immediately challenged in federal court. Illinois gun owners filed suit. Advocacy organizations filed suit. The challenges are ongoing. But here is the brutal truth that the legal challenges do not change. The law is still in effect. The registration deadline passed. Gun owners who own firearms covered by the Act's definitions and who have not registered them are in violation of state law right now, today, with criminal exposure that is real and actively enforced. The fact that the law may eventually be struck down in court does not make you legally protected today. Courts do not retroactively unprosecute cases. Legal victories in the future do not erase criminal charges in the present. Washington State has enacted significant restrictions on semi-automatic assault rifles, including sales and transfer restrictions that affect both dealers and private owners in ways that can catch people off guard if they're not paying close attention to what the law actually requires. Maryland has a specific list of prohibited firearms and a regulatory mechanism that allows that list to be expanded without legislative action, which means a firearm that is legal in Maryland today could be prohibited next month without a single vote being cast in the state legislature. And while the Bruen standard has given courts a powerful analytical tool to strike down these laws, the circuit courts are not in agreement. The Fourth Circuit has upheld Maryland's ban. Other circuits have ruled differently on similar laws. The Supreme Court is expected to take up assault weapon bans directly in the coming terms, but expected to is not the same as has, and until that Supreme Court decision comes down, the law in your specific state is the law you have to comply with, not the law in Texas, not the law you think should apply, the law where you live. Hit that subscribe button and turn on your notifications right now, because this kind of analysis, real, detailed, legally grounded, without partisan spin, is exactly what we do here every single week. And the next update on these laws could be the one that directly affects something you own. I want to talk now about what might be the most dangerous category for ordinary gun owners. Not because it affects the most people, but because the consequences of getting it wrong are so severe, and because the way people end up in this situation is often completely inadvertent. National Firearms Act items, suppressors, short-barreled rifles, short-barreled shotguns, Machine guns that are not properly registered and documented under NFA requirements. This is not new law. The National Firearms Act has been federal law since 1934. The category of regulated items, the registration requirements, the tax stamps, the transfer rules, none of this is new. But in 2026, federal enforcement of NFA violations has received renewed and intensified emphasis. And the thing that most gun owners do not fully internalize about NFA noncompliance is the severity of the legal consequence. Possessing an unregistered NFA item is not a misdemeanor. It is not a regulatory fine. It is a federal felony. It carries up to 10 years in federal prison, and it results in permanent lifetime, loss of your right to own any firearm ever again. And it can happen, and this is the critical point, through no malicious intent on your part whatsoever. Here is where the pistol brace situation from earlier in this conversation becomes something darker. The ATF's 2023 rulemaking, the one that reclassified brace-equipped pistols as potential short-barreled rifles, created a scenario where gun owners who believed with complete sincerity that they owned a legal pistol may have inadvertently created an unregistered short-barreled rifle, according to the regulatory definition. They didn't manufacture a machine gun in their garage. They didn't file down a sear. They didn't do anything most people would recognize as a crime. And they put a legal brace on a legal pistol the way millions of other people did. And because of the way federal regulatory definitions work, they may now be in possession of an unregistered NFA item without knowing it. Then is the modified firearms category, which deserves its own serious attention. Common examples: auto sears or switches installed in semi-automatic firearms that convert them to full auto operation, which is a federal felony under current law for weapons manufactured after 1986 period. Full stop, regardless of how the modification was done or who did it. Binary triggers in states that now specifically prohibit them. Forced reset triggers, which are themselves the subject of ongoing ATF regulatory action and are in legal flux right now in 2026. Shortened barrels without NFA registration, magazine modifications in states with capacity restrictions, and the scenario that catches people most off guard, buying a used firearm from a private seller, from an estate sale, from a friend, and having no idea what modifications were made to that firearm before it came into your hands. Because when federal law enforcement shows up, I didn't know is not a defense. Ignorance of the law is not a defense in federal court. The firearm is either compliant or it isn't. And if it isn't, the criminal liability is yours. Here's what I want to leave you with. And I'm going to be direct because this matters more than any legal detail I've covered. The legal battles over these regulations are real. They are significant. And gun owners are winning, some of them. Under the Bruen standard, courts have struck down regulations that have been in place for decades. The Supreme Court has demonstrated that it takes Second Amendment rights seriously as actual constitutional rights, not second-class rights that exist only in the spaces where government chooses to allow them. Organizations like the Firearms Policy Coalition, the Second Amendment Foundation, and Gun Owners of America are winning cases that were unwinnable 5 years ago. That is a real and important development, and you should know about it. But legal victories operate on legal timelines. They take months. They take years. They wind through district courts, circuit courts, and the Supreme Court on schedules that have nothing to do with the enforcement actions happening right now, in the present tense, to real people living real lives. So here's your complete 2026 Legal Protection Action Plan, and I am asking you to take every step of it seriously. First, conduct a complete, written inventory of every firearm you own. Make, model, serial number, modifications, acquisition history. Keep that inventory somewhere secure. That document is the foundation of everything else. Second, go through that inventory and identify any firearm that falls into the 5 categories we've covered: pistol brace, equipped firearms, unserialized privately made firearms, firearms that might qualify as assault weapons under your state's law, anything that might qualify as an NFA item, and any firearm with modifications that you didn't put there yourself or that you're not certain about legally. Third, contact a licensed firearms attorney, not a general practice attorney, not a Reddit forum, not a YouTube comment section, a firearms attorney who practices federal firearms law and the specific law of your state and get a specific legal opinion about your specific firearms. The cost of a legal consultation is not nothing, but it is nothing compared to the cost of a federal felony defense. Fourth, know your state's current assault weapons law and high-capacity magazine restrictions in detail. If you live in Illinois, California, New York, New Jersey, Maryland, Massachusetts, Washington, Colorado, Connecticut, Hawaii, or Delaware, your state has specific laws with specific definitions and specific compliance requirements that may apply to guns you currently own. Know them, know whether registration deadlines have passed, know whether grandfathering provisions apply to what you have. Fifth, if you own NFA items legally, suppressors, short-barreled rifles, legally registered pre-86 machine guns, ensure your documentation is complete, current, and accessible, your tax stamp, your Form 4 or Form 1 approval, your trust documents if you hold your items in an NFA trust, all of it in order, all of it ready to produce. Sixth, stay connected to Second Amendment legal developments through reliable sources: the National Shooting Sports Foundation, the Firearms Policy Coalition, the NRA's Institute for Legislative Action, Gun Owners of America, When the Law Changes, and it is changing faster right now than at any point in recent memory. You need to know about it immediately, not after enforcement has already started. And seventh, know your state's safe storage requirements. An increasing number of states have enacted mandatory safe storage laws, particularly in homes where minors are present, and violations of those laws are being actively prosecuted in jurisdictions where they exist. The system is not going to warn you. The ATF is not going to send you a letter. Your state legislature is not going to knock on your door and explain that something you bought legally is now the subject of a criminal statute. That is not how any of this works. The responsibility for knowing the law falls on you, and that is not fair, and it is not right, and it is a failure of clarity that the government owes its citizens but refuses to provide, but it is reality. And living in reality means doing the work right now, today, not next week, not after. You see how the Supreme Court rules to make sure that you are protected, regardless of how these legal battles ultimately resolve. If you found this reporting valuable, and I believe it is some of the most practically important information you'll encounter this year as a gun owner in America, subscribe to this channel, share this video with every gun owner you know, and leave a comment below telling me what state you're in and what questions you still have, because we are not done covering this story. The legal changes we are watching in 2026 will define the landscape of Second Amendment rights in this country for the next generation, and you deserve to understand what is happening and what it means for you specifically and exactly what you can do about it. That is what we're here for. Stay sharp, stay informed, and protect your rights while the courts are still fighting to define them.